Hi, I'm Johanna Weaver, and you're listening to Tech Mirror, a podcast that talks about how humans shape technology and how technology is shaping our society. Hi, listeners, and welcome back to Tech Mirror. I know we've had a little bit of a hiatus recently, and it really wasn't intended to be that way, but well, things have been a bit busy, mostly for good reasons, but please be assured that this episode represents the return to normal servicing. And who better for us to be doing this with than Carly Kind, Australia's new Privacy Commissioner. Carly, welcome to Tech Mirror.
Thank you for having me.
We're delighted to have you. And look, I think part of the reason I'm so excited to have you on is because the new role that you're filling and the separation of the Information Commissioner and the Privacy Commissioner, but also because of your history and your background. So for listeners who don't know, before Carly was appointed the Privacy Commissioner, she headed up the Ada Lovelace Institute in London, which has a mission really looking at how AI and data to maximise social wellbeing and put technology to the service of humanity, which is quite familiar to the mission of the Tech Policy Design Centre that we have here. So, Carly, one of the things that I immediately thought when I saw your appointment was, I wonder what it is that has made her say yes to this job. So, you've worked overseas for 15 years. You are an Australian and we're delighted to have you home. What is it that makes this role the right role for you now?
Well, part of it was that I was a week away from having a baby when I saw the role advertised. So perhaps I was in a kind of prenatal kind of zone where I thought wildlife decisions are all on the table, let's go. But in reality, I think what really appealed to me about this role at this point in time is, as a privacy advocate and somebody who has been passionately working on these issues now for almost 2 decades, I really do think that Australia is one of the most exciting places to be when it comes to advancing privacy protections at the moment. And that's for a few different reasons. I think, you have a outdated legal framework that is on the brink of change and is on the brink of reform. And that is a hugely exciting professional challenge for me, but also an exciting opportunity for Australia. So I really, chiefly found that quite appealing to come at this point in time. But also we have really interesting economy and place in a kind of rapidly changing geopolitical ecosystem that means that I think Australia can adopt some bold policy approaches that aren't available or aren't of interest to other countries. And, I've spent the last 15 years in the UK. I think that the UK has been in a very specific place when it comes to politics and power that has really shaped the way in which it has, for example, tried to curtail the worst aspects of platform capitalism and big tech monopolies, and not least the desire to try to attract some of those companies to the UK economy. And I think that Australia is in a different place, which means that, the market is different. The potential for AI and the way in which AI investment might go is very different here than it is in Europe, for example. And so that means different types of interesting policy proposals have been on the table here. And I think from a perspective of an advocate and a lawyer, that's really exciting to think about where interesting policy proposals might go and how they get implemented and from a regulatory perspective, how they get regulated as well.
So a little bit of a cheeky question for you. Let's imagine now that you are at the end of potentially your first term. So your son would now be 6 years old.
That's right.
How would you measure success? What would give you satisfaction to be able to look at that 6-year term and say, I've done something good for the world or good for Australians?
I think a really simple metric would be, is the standard of privacy protection for Australians higher than it was when I started? That's really the kind of baseline achievement I would like to get to. But more ambitious than that, I would really, really love to see the successful adoption and implementation of, wholesale reforms to the Privacy Act. Now, that is not within my gift to make happen, at least initially. That is the Attorney General and government's imperative, but to support that process and to see its implementation through, which will require a lot of work from the Office of the Australian Information Commissioner, and to help the organisation make the transition from a kind of pre-technology regulator to a technology-first regulator. And I mean that in a lot of different ways. I think really working out how to regulate technology and see the Privacy Act applied effectively in the technical domain, but also to use technical tools to enable regulatory action, I think is a really big challenge for regulators in the age that we're in. And that's really an exciting challenge that I'm looking forward to sinking my teeth into. So I hope at the end of my term, I will have equipped the office with the kind of skills and ambitions to be that technical and technology first regulator.
Seeing your appointment as Privacy Commissioner, but also with the ongoing role of Angeline Falk as the Information Commissioner, I've had lots of conversations with people who are grappling with how to understand the two different roles. So can you talk to us a little bit about the difference between your position and Angeline's position and how they interact and work together?
Yes, absolutely. So with my appointment, the Office of the Australian Information Commissioner has resumed the 3-commissioner model that was part of the aspirations originally for the office, which means we have a Privacy Commissioner, dedicated Privacy Commissioner myself, a dedicated Freedom of Information Commissioner, currently Elizabeth Tidd, and then an Information Commissioner, Angeline Falk. The Information Commissioner is the agency head, so they have the kind of statutory authority to run the organisation as a government agency. And that means that they have lots of the responsibilities and obligations with respect to staffing, staff policies, accountability, lines of reporting back to government, etc. And the Information Commissioner also has a subset of exclusive responsibilities, both with respect to certain information-related policy and legislation and government's handling of information, but also with respect to some of the kind of pointier functions of our office, for example, in the enforcement realm. So litigation has to be instituted in the name of the Information Commissioner. Whereas my remit is really to advance the privacy-related aspects of our various legislative responsibilities. We have responsibilities under 35 pieces of legislation. You know, a subset of those relate to privacy. And so my responsibility is to oversee the successful implementation and regulation of those responsibilities, all in the privacy domain. There are some kind of boring logistics about what the Information Commissioner has jurisdiction, as it were, over what can be delegated to the Privacy Commissioner, what can be exclusively done by the Privacy Commissioner without consultation with the Information Commissioner, etc. But I think the important takeaways for your audience are it's a complicated structure in theory, but the way we're choosing to run it in practice is as a very collaborative and consultative, essentially governance board of 3 people who oversee the organisation together and make decisions by consensus where possible. And in that respect, we might be more aligned with some of the other regulators who are specifically run by boards of commissioners. We are seeking to kind of take that general approach to the running of the Office of the Australian Information Commissioner, not least because we see all of these functions, government, information handling, privacy, and freedom of information, essentially boiling up to, you know, control of Australians' information, and that there being lots of kind of virtuous cycles and relationships between all of those functions that we really want to try and maximise and leverage the entire office in pursuit of. So working together to collaboratively run the organisation is really a big objective for us.
Yeah, I mean, that's wonderful to hear that, and I had no doubt that would be the case, knowing the folks involved. You've mentioned there privacy law reform, also litigation. I do want to come to litigation, but let's talk first about the privacy law reform. The Attorney General has said that we can expect to see law reform in August. Lots of people are waiting with much anticipation about this. What privacy protections do you think listeners should really be watching out for when that the package is released? And this is really the government acting in response to the privacy review that had been long ongoing.
So we continue to very much support the ambition of the Privacy Act review and all of the reforms that are on the table. We very much hope government will choose to proceed with all of them. It's a really diverse and varied package, incredibly rich and incredibly detailed in certain aspects. But as a whole package would really parachute our privacy protections forward in Australia. So that's why it is so exciting. If I can highlight a few of the individual proposals that might be of interest, I think the one that has gotten the most attention is the introduction of a fair and reasonable test for the collection and use of individuals' personal information. And why this is important is that it puts the onus back on entities who are collecting individuals' personal data to ensure that they're acting in a fair and reasonable way when they collect and when they use and when they disclose that data. That's not a requirement currently under Australian law, and I think many Australians would be surprised and possibly horrified at that.
Yeah.
But there's not any obligation on the collecting entity to ensure that they handle it in a fair and reasonable way and to consider other considerations. For example, if it relates to a child, is it in the best interest of the child that I use and collect the data in this way? That's not currently the case under Australian law. The threshold is much lower at the moment, which is that the collection has to be reasonably necessary for the organisation's function. So it really is much wider.
It's a very different test.
Exactly, a very different test. And this would really narrow the circumstances down under which an organisation can legitimately and justifiably ask for an individual's information and retain that information. And this is really important for Australian people who know very well the risks of organisations collecting and holding on to a lot of data. We've seen some huge data breaches in Australia in recent years. And it is very apparent, I think, to most Australians now that lots of organisations ask for data they don't need and they hold it for longer than they actually need it. And so this fair and reasonable test, we hope, would very much start to curtail the circumstances in which organisations are collecting data. And it would have to come, of course, with some very clear guidance from the Office of the Australian Information Commissioner about what constitutes fair and reasonable, and some clear enforcement action where organisations are blatantly disregarding that guidance and pursuing really egregious uses of collection of data that clearly fall outside of a fair and reasonable test. Enforcement action is another area in which the Privacy Act reforms would advance the situation because it would give our office a greater range of powers to issue warnings against actors who are non-compliant with the Privacy Act, but also to institute court proceedings for conduct that doesn't reach such high levels as is currently required in the legislation. Currently, we have to establish that interferences with privacy are serious or repeated. The proposed legislation would introduce medium and low tiers of penalties as well, which means that we would just have few more tools in our toolkit in terms of going after the worst offenders. A final point that I'd highlight for your listeners would be the proposals around children and the protection of children's privacy. I think this is really important for most Australians these days as we become more and more aware of the risks and concerns, particularly in social media platforms for children. And the Privacy Act reforms include a range of different protections for children, including giving our office the ability to develop a children's online privacy code, which would really spell out for actors how they protect children's privacy online, as well as restrictions on when children can be the subject of targeted advertising, for example, which is a really key protection in this digital era.
The fair and reasonable test is such a fundamental shift, right? It takes it from, is it good for the business to, is it good for the person whose data it is, which I just think is such a important shift that Australia desperately needs to implement. One of the things you've talked about there is the Children's Privacy Code, which was also something that was looked at in the ACCC Digital Platforms Inquiry, which I guess just makes me think about or reflect on the relationship between all of the different regulators that we have in our digital economy. So how do you see your work, the work of the Office of the Information Commissioner, working alongside, for example, the ongoing digital platforms inquiry for the ACCC?
It's clear that all of the regulators in the digital realm, while each have a really important, I think, sphere of control and authority, have to work together to ensure that there aren't any gaps in the protection for Australian people, but also that where there are overlaps, those overlaps don't actually result in lower levels of protection. And I think that is actually really a risk worth pointing out, that when you have two regulators that have overlapping remits, there is a risk that neither regulator takes action because each assumes that the other has their eye on that particular issue. So coordination is key. And my predecessor, Angeline, and colleagues have been really aware and alive to this risk and this challenge, and in recent years have been critical in developing the Digital Platform Regulators Forum, which is a grouping of 4 regulators, the OAIC, the ACCC, the eSafety Commissioner, and ACMA, the Communications Regulator, coming together to ensure that there's alignment in terms of enforcement investigations, compliance activities, as well as to kind of leverage and utilize each other's expertise on emerging issues. So that's the vehicle through which we've started to look at AI, for example, and the regulation of AI technologies in different respects. So I think that kind of collaboration, which is being modelled really well elsewhere, including in the United Kingdom, is a really key way to coming at these issues that you've pointed out, Johanna, because it's clear that in the current digital economy that we're looking at, many issues will be both, for example, competition issues and privacy-related issues. And collaboration between those actors is actually kind of key to getting at the heart of the issue, as well as ensuring that there's appropriate regulation in that space. So we're certainly all alive to that. And I think, we talk regularly with our co-regulators in other jurisdictions, and we really do work to try to leverage expertise and make sure that there's coverage from every angle.
It's music to my ears to hear you say coordination. One of the first reports, in fact, it was the first report that TPDC put out was Tending the Tech Ecosystem, and a partner report, Cultivating Coordination, which was looking exactly this issue of regulators, coordination of regulators in Australia on digital issues. And it is our first set of reports, but also probably our most quoted and most referred to, even though it's now a couple of years old. So that's wonderful to hear. One of the areas where I think the relationship with the ACCC and the Privacy Commissioner is going to become really important will be in relation to digital identity, noting that the bill has just passed Parliament. It's waiting for royal assent, likely to come into force in November. What's interesting about the digital identity legislation is that it actually has dual regulatory roles, part for the ACCC and also part for your office. Could you talk us through how, given how central digital identity will be for Australians, how that division of responsibility for oversight of digital identity is going to be divided up?
So essentially the way the digital ID system works is that the ACCC is kind of the accrediting regulator. So for entities to become accredited participants in the system of identity provision, they will have to go to the ACCC to get accredited. And accreditation, confusingly, does also involve some demonstration of privacy compliance in different respects. Through some interesting legislative drafting choices that were made, there are privacy standards that have to be complied with through the accreditation process. And then separately, once the entity is accredited, there are privacy safeguards that they will have to comply with. And those privacy safeguards are within the jurisdiction of the Privacy Commissioner, the Office of the Australian Information Commissioner. So we oversee compliance with the privacy safeguards by accredited entities. ACCC will be doing the accrediting. There's also an interesting facet, which is that state regulators of privacy will also have a role to play, where an entity who's already regulated by a state privacy authority in a jurisdiction where there's comparable levels of protection to the Commonwealth privacy regime participates in the digital identity system, then potential complaints or non-compliance with the State Privacy Act will be covered by the state privacy regulator. Potential complaints with or non-compliance with the privacy safeguards will be regulated by the OAIC. So, and there it goes down to quite a detailed level. The privacy safeguards speak to some very specific things about the particular types of information collected in the digital identity systems. For example, the privacy safeguards include a prohibition of collecting certain types of data on kind of racial or ethnicity data, for example. That can't be collected by accredited parties within the digital identity system. And those are the kinds of safeguards that the OAIC will be regulating. But generally speaking, at a high level, I think we are very keen to hold ourselves out as being the kind of privacy watchdog of the digital ID system, and that we will have our eye on privacy interferences and violations across the digital ID system, not least because we really believe in the digital ID system as a route to improving privacy protections. We can ensure that this system functions well for everybody involved, including chiefly Australian consumers, then we hope to see a reduction in the amount and scope of identity documentation being taken by organisations in the Australian economy and being retained. And we hope that a well-functioning digital ID system will see businesses move to using an identity system rather than acquiring identity data themselves and holding that, which we think really creates risks.
Yeah, and look, for listeners, we will do an episode shortly on digital identity because, as you can tell, it's quite complex, but it's so important. And I think we need to demystify some of these things. And I'm lucky enough to be on an advisory board with Minister Shorten, looking at some of these issues and have done a number of deep dives. And I think we'll come back and bring some of that or share some of that knowledge with you. I guess one thing to round out that topic, Carly, you have described quite a complex regulatory oversight. Are you genuinely comfortable that there are the right privacy protections around our digital identity infrastructure? Do you think that, notwithstanding the complexity, that we've got the right bits of the puzzle in place?
I think we do have the right bits of the puzzle in place. I think I'm quite impressed with the approach that has been adopted. There's a lot of work being done by colleagues in finance and elsewhere to make sure that there's a lot of consultation, including with remote communities and vulnerable groups. There's really a lot of thought, I think, being given to how to make this system a success. With good reason. That digital identity has not had a lot of luck in many other jurisdictions, including the UK, where I came from prior to this role. It has been a bit of a cursed project, a cursed transformation project in many different economies. So it is hard to get right, and it's going to be hard to get right in Australia, given there has been some historical reluctance to support national identity systems. There wasn't, as I understand it, a wonderful experience of, for example, digital apps during the COVID crisis. So I think there is community-wide suspicion or reluctance around some of these systems that will have to be overcome. And there's a lot of thought being given to that. And, putting the OAIC in a central role is part of that, to make sure that privacy really is right at the forefront. Because, like you, Johanna, many people will have an instinctive kind of concern or, about how these systems work. So I am confident that the building blocks are there. I think the challenge may be for individuals and for regulators in a very complicated system where there are problems or failures, will be identifying responsibility, identifying the appropriate regulators to take that forward. And so that's really what we'll have our eye to as the legislation comes into effect.
Yeah, and I think because of some of the reticence you're describing, it's part of the reason why I've really spent a lot of time wanting to understand the ins and outs of what is, it's a complex regulatory environment, but actually the technical infrastructure is also very complex. And so that's what we'll touch on in another episode. You're listening to Tech Mirror, a podcast from the Australian National University's Tech Policy Design Centre. If you like what you're hearing, we would love it if you could give us a 5-star rating, or even better, leave us a short review on your podcast platform of choice. Now, enough interruptions from me. Let's dive back into this episode. Carly, let's switch tracks a little bit and talk about the TicToc inquiry. What I was fascinated about when I read the press release about the TicToc inquiry was the way that it was phrased so clearly to say that there's no obvious breach of Australian law here, but that you were so express in saying that you're concerned about these intrusive tracking practices. You're making a very conscious decision about directing, litigation resources where you can have the greatest impact, and reading between the lines decided that you wouldn't be successful with TicToc. How do you think this sits for us in terms of the privacy law reform and the things you're looking to have strengthened in that package of reform that we're looking to see coming in August. And have I read the tea leaves right there in how I've summarised your press release?
Yeah, so it is a complicated matter, and what my objective in writing the op-ed was to try to open up the hood a little so that it was clear to people the kind of steps we go through to establish whether or not we're going to investigate a set of practices and all of the very complex considerations that come into play there. In the case of TicToc, while I acknowledge that tracking pixels on the internet, which send our personal browsing data back to social media companies, is an incredibly invasive practice. And personally, I feel that it shouldn't be permitted within a strong privacy framework. It is, I think, one of the more depressing technological developments that we've seen over the last decade or so, in which these exciting new technologies have actually become vehicles for enabling more and more targeted advertising, essentially, through the tracking of individuals' behaviour. So I have real problems with that entire economy that trades in our personal information. Nevertheless, establishing a breach of the Privacy Act requires establishing to the requisite threshold that there has been some non-compliance with privacy law. And in the case of tracking pixels, the way in which our legislation is framed doesn't necessarily, or in any clear and obvious way, make the receipt of that information by social media platforms unlawful, provided certain things are in place, which in making initial inquiries into this issue, we were able to establish they were. So when we as an office are alerted to an issue of concern, and keep in mind we get around about 2,500 complaints every year, we also initiate our own investigations off the back of things we see in the media, things that are elevated to us through expert groups, civil society, academics, etc. We have to make a choice about where to point our resources in. And the way we do that is we start by making some initial inquiries into an issue. That may involve reading a few papers. It may involve making a few phone calls, speaking to some experts, drawing on our own internal expertise, and in some cases writing to an entity to ask them to voluntarily give us some information before we open an investigation. We did all of those things in the case of TicToc. And at the end of that initial inquiry phase, we have to decide, are we going to move into an investigation, which is a legislated process under the Privacy Act, which enables us to exert some very powerful powers, including notices to produce documentation or enable access, to conduct examinations of relevant people, etc. Or do we not think that it's going to be worthwhile pursuing this, either because the scale and scope of the violation doesn't warrant it, the prospects of success are slim, the resources involved are simply too big for what we have available to us, or we have a range of competing other things that we have to pay more attention to. So it is quite a difficult triangulation process to decide whether we're going to pursue these things. In this case, the combination of there was no apparent clear violation of the law as written, paired with these other considerations, meant that we didn't feel it was warranted to pursue TicToc on this occasion. Although we continue to look at the provision of personal information via pixels to social media companies, and in particular, we're concerned that the provision of sensitive personal information, including health data, may be occurring, and that's something that we're going to be hopefully taking forward. In terms of how Privacy Act reform might better empower our office to do something about this issue should it come before us again, I think the fair and reasonable test arguably would go some way to prescribing these kinds of behaviour as unlawful. And that's because within the auspices of the fair and reasonable test, as it was drafted in the Privacy Act review, the entity has to take into account a range of specified considerations. And one of those is, for example, does the interference with privacy outweigh the benefit gained? And I think that there would be, it would take some time for it to filter through the courts exactly what the standards are there. But I think there would be a really strong case to make that simply collecting and disclosing information because it helps you market to individuals isn't a justifiable collection of personal information. It's not a defensible intrusion into people's privacy just to do that because it enables you to sell them ads. And I think trying to develop our framework to get to that point would be part of that process were that standard to be developed. And of course, again, the enforcement powers available to us could be expanded through the Privacy Act such that we wouldn't have to meet such high standards to get a matter into court, for example. Again, as I said, at the moment, we have to reach quite a high threshold before we're able to institute civil penalties proceedings. Should Privacy Act reforms expand out the scope of penalties we're able to pursue, it may be that the thresholds reduce in certain cases, and that means we would, slightly adjust our own internal protocols as to which matters we take forward into investigation.
First of all, I want to say how refreshing it is to hear you frankly expressing concern for a behaviour whilst also acknowledging that it's not currently prohibited under Australian law. I think, a lot of Australians would share the concern that you have, and it just highlights the importance of the privacy reforms that we're expecting to see brought before Parliament in August. And as I said, we'll be watching that really closely. You mentioned there the need to look and prioritise because there are so many issues that come before you. A couple of the other things that I've seen you refer to in public conversations that are issues of priority that the office is looking at are things like the governance of biometric data, connected cars and artificial intelligence, which, I think the last one at least wouldn't surprise anyone. But let's maybe just briefly touch on each of those. So biometrics, let's start there. What is it about those technologies that is of particular concern that's capturing the attention of the Privacy Commissioner yourself, but also more broadly the office?
I think biometrics technologies are really top of most people's list, certainly on the basis of, what we hear from the Australian public and see in our complaints trend data. They're really at the top of concern when it comes to privacy. And I think there's a few reasons why that is the case. Many of them, particularly facial recognition technology, are very evocative. They're kind of tangible instantiation of, I think, some of the practices we feel like we're experiencing online, but maybe we can't see.
Yeah.
I've just been talking about targeted advertising. We all have that feeling where we've been talking to somebody about the new shoes that we'd like to buy, and then we go home, we're scrolling through Instagram, we see the shoes on Instagram. That feeling of being profiled or tracked online. I think facial recognition and other biometrics technologies are a really tangible instantiation of that technological development. And so, it feels like to many people like in recent years they've woken up and they're in a science fiction film or they're in Minority Report and for that reason I think it's become a useful vector to talk about privacy issues to people, but it's also become a real side of concern for many people. And I think that's why it's risen to the top of many people's agendas. From a legal perspective, biometrics data is some of the most sensitive and intimate information about people. And importantly, it is immutable. So if it gets lost, there's nothing you can do about it. Whereas if your passwords get stolen, you can change your passwords. If your face print gets stolen, you can't change your face, much as many of us would like to.
Oh, don't say that.
I was definitely not referring to you. I was referring to myself.
That's even worse.
I do think that it is incredibly valuable and intimate information, and it really deserves high levels of protection. And I think that is why people have become so concerned about it. Yeah. I think it is also a clear example of where the technology has run ahead of where legislation might need to be, or at least the enforcement of legislation might need to be. And we really have seen this rapid advancement in the last 5 or so years because of the developments in image recognition technology around things like facial recognition. And I'm not sure that public confidence and public comfort has kept up with where the technology is. So that's I think the gap that we're playing in as regulators at the moment.
I mean, in general, I'm a very strong proponent for technology neutral regulation, because otherwise we're never going to be able to keep up. But there are, and I think that's an approach that most experts in the field generally agree with, but there is, I think, a point of difference around whether or not we need special laws and protections around biometric data. Where do you fit on that spectrum? Do you think if the Privacy Act is strengthened in the way that we're expecting it to be, do you think that is sufficient to also regulate biometrics data, or do you think we need something more because of the sensitivity of that information?
I suppose I tend to agree with you, Johanna, that the best legislative frameworks are the ones that are as general as possible when it comes to specific technologies. So I would generally be in favour of a framework, which I think is the approach of the Privacy Act reform, which takes primarily general approaches to regulating personal information, but specifically mentions and provides additional protections for certain types of information, which I think is a technology neutral approach, but nevertheless recognises that biometric information or genetic data, for example, is deserving of higher levels of protection. I'd add a couple of things to that, however. Many existing legal frameworks do regulate biometric information as a special category of data, but only when that biometric information is used for identifying individuals. I think what we are going to see with technology is that biometric information is going to be used for a whole range of other things. It's not about individual identification, but is about classification. And that includes, for example, emotion recognition technologies or sensors on immersive gaming, which enable assessments of heart rate and stress levels, etc. And again, all really sensitive, intimate information might not be about identifying the individual, but certainly would be about knowing a lot more about that person, potentially for the purposes of influencing their behavior or otherwise. So I think recognizing that that particular data is deserving of higher levels of protection is really important. The other thing I want to say is that this week I went to the Australian Human Rights Commission's symposium on neurotechnologies and human rights. And that was another space in which we see the emergence of a new field of data, which is neurodata, or as some Latin American countries are protecting it as cerebral data. And I think that might be an emerging gap already that we're seeing that technology is pushing into, that we need to think about how we amend existing legal frameworks with respect to. Again, I don't think that's about making it a technology-specific piece of legislation, but it is about acknowledging these emerging categories of data that could be then folded into other pieces of law. So I think that, for me, that feels like the right approach.
Yeah, I am very much on board with that approach. Another area where people often feel we're falling behind is around artificial intelligence. You have spoken about this, expressing concern that the pace of the technology rollout, acknowledging that artificial intelligence already exists widely in our economy, is happening so fast that perhaps we're not really considering the impacts and regulatory options. How are your team thinking about artificial intelligence and the way that it will perhaps present new and novel challenges to the regulation of privacy?
It is a difficult one for us because it requires an immense amount of work to think about how to apply existing laws into the domain of these new technologies, which are changing so quickly, and which each new instantiation of really raises new legal questions. That being said, it's absolutely our aspiration and our intention that the Privacy Act applies to artificial intelligence, and that we will be in a position to articulate exactly how and what the Privacy Act requires of these new technologies. We haven't done that yet, is the short answer. And I do think that there is a responsibility inherent on regulators to actually get out and start talking at a detailed level about what regulation requires of artificial intelligence, rather than to stick at the higher level of saying, the laws apply. I think we do need to get into the detail of how they apply. And I think, regulators around the world have been struggling to keep up with that. I think we've seen some pretty impressive attempts by, for example, the Italian data protection regulator around ChatGPT. But we've also seen that nothing has really stuck yet, I think, in terms of shaping the development of AI through the application of privacy laws. And I think that is a big challenge for privacy regulators, and one which we are also really engaged in thinking hard about. So I'm not sure how satisfying that is as an answer, but I would say that it is a challenge because the technologies are very complex and the actors are very powerful, and the jurisdictional issues are complicated. So we as regulators do need to get on the front foot, I think, to start to be prescriptive about how we expect these technologies to fall in line with privacy law. And that's something that I'm going to be working on with my office.
Yeah. And I think for anyone who's looking to track what other countries around the world are doing in the regulation of artificial intelligence, I'll do a short plug here for the Tech Policy Atlas, which if you Google Tech Policy Atlas, which my team is updating every day, we currently cover almost every single jurisdiction in the world. And it covers everything from privacy to competition to cybersecurity. It's a massive database and a very easy to search and track what's going on around the world. Carly, I think perhaps as a penultimate question for you, acknowledging what you're saying there about the challenges of regulating new and emerging technologies, can you talk a little bit about how you see privacy or privacy law and regulation as essentially a check and balance on power, and how we can use it as a tool to actually correct some of these imbalances? Because I think it's nice to, we've talked about many of the challenges, but it's also, I think, important to remember that these are powerful tools that we have, and we have amazing people like you in your office grappling with how we implement it. But what does that mean from sort of a societal perspective?
Yeah, I absolutely see it that way, Johanna, which is that, if we go back to where the privacy as a concept has been talked about in literature and art for thousands of years. It's been very important in certain religious traditions and in politics and in all sorts of places. When it became instantiated in human rights law, as I'm sure you well know, after World War II, that decision to put it as enshrine it as a right in the Universal Declaration of Human Rights very much linked to the notion that it was through interferences with privacy in the 30s and 40s that autocratic governments were able to inflict some of the worst harms on individuals and to really undermine human dignity. And so the origin of the right to privacy is very much acknowledging that people need an individual space to be free from outside influence to make autonomous decisions about their lives. Over time, what that means in practice has changed dramatically, because the ways in which our autonomy can be infringed upon have also changed, and they have become perhaps more obscure from us and obfuscated from us. They've become perhaps smaller in size, but larger in number. So there are many, many small ways, I think, on a daily basis in which our private spaces are infringed upon, including through the uses we have of technology. And where I end up is not saying that we shouldn't use the technology, but by saying the technology needs to be better. The technology itself can enable us to exert our power and to enjoy our privacy. And I think that's why, I always come at privacy from the perspective of control. It's not about hiding. It's about having control over who has access to what information about you. And you should be able to live your life as a, TikTok superstar who talks about what they had for breakfast on TikTok every morning, and still make a claim to your privacy and still say that I am controlling who has information about me, because I am able to, for example, fine tune my privacy settings, or ensure that advertisers can't use my information without my knowledge and express consent, etc. I really think it's important that we all remember that we should be able to have our cake and eat it too when it comes to these new technologies, because they're only 10 years old. The way in which they're designed currently does not have to be the way in which they're designed in 5 or 10 years' time. And I think coming at it through the lens of privacy and really understanding how, through very small changes, through the intervention of regulators like myself and through the developers of technology, privacy-preserving technology products, of which there are increasingly more, we are in the process of evolving the current state of things towards a more privacy-protective digital ecosystem. At least that's what I hope, the journey that we're on.
Yeah, I could not agree more. I mean, that's essentially what we look at to do at the Tech Policy Design Centre, is actually enliven people in a sense of agency that we can shape the technology and have that technology work for us more, rather than us working for the technology as it is the case now. Carly, I'm sure you get this question all the time, but it's an important one. When people are feeling a bit helpless, like the privacy has been let out of the bag, and that they want to keep using these technologies, and they're hopeful that we will reshape them into privacy protecting technologies, but they're not quite there yet. What advice do you give to people who have that concern? Do you have any tools or go-to resources or things that you recommend to people?
That's a great question. I think that small acts of defiance are how I certainly get through the day. For example, if every single time I buy something from a shop and they ask me if I'm a member and would I like to become a member for 10% off, I say no. And I think to myself, would I pay $10 in a month's time for this person to stop sending me emails and, stop tracking me? Absolutely yes. So I'm not going to take the short-term, potential supposed benefit of a loyalty scheme for the long-term pain of being, marketed to and tracked across my various accounts. And I feel a small sense of success at every one of those small interactions that I have. I realize, though, for most people that does get tiring, and it's also can be a position of privilege to say I'm not going to take that discount that's offered to me by handing over my information, and people shouldn't have to be in that position. You shouldn't have to pay for privacy. It should be equally free to everybody. But I do think that being alive and aware and trying to exercise the choices we do have is just one really important way of starting to reclaim a bit of that feeling of agency, questioning whether does that organization really need my place of work, or do they really need my date of birth, and trying to just, challenge in small ways that those practices. I think each small act, can make a difference over time.
Yeah. Thank you so much for being with us today. Your expertise, but also your passion for the subject really come across. I'm really excited to have you back home in Australia and look forward to working with you and your team and seeing in what direction you take the role. So thanks for being on Tech Mirror.
Thank you for having me. It's great to be back. I wish it was a little warmer. I think my 15 years in the UK, I spent just dreaming of how warm Australia is at all times. And now I'm really suffering through my first winter in Sydney and finding it absolutely freezing. But other than that, it's wonderful to be here.
Thank you. And thanks for being on the pod. We'll talk soon.
Great. Thank you for having me.
Tech Mirror is a podcast of the Tech Policy Design Centre at the Australian National University. This episode was recorded on Ngunnawal lands with sound engineering by ANU Studio. Amy Denmead provided invaluable research support. Post-production is by Martin Franklin from East Coast Studio. Thanks for listening. Get in touch and get involved.